Welcome to the Tightrope, best practices for PSAs in oil and gas transactions. We appreciate everybody out there tuning in. My name is Shaun Schottmiller. I am a partner here at Oliva Gibbs. My practice involves both operational and transactional work, as well as some title work as well. We'll be walking through a number of slides, and we'll provide a slide deck for you and a follow-up email. With me today is Braedon Morrow, and I will let him introduce himself, and then he will continue with the presentation.
All right. Good afternoon, everyone. Thank you, Shaun. As Shaun said, my name is Braedon Morrow. I'm a senior attorney here at Oliva Gibbs. My background is in transactional law matters, predominantly in the upstream oil and gas space, which includes both acquisition and divestitures and some M&A. Also have some background in commercial agreements and other midstream contracts as well. So with that, let's jump into our overview of today's webinar. So I want to welcome each of you to our session. It's focused on a critical aspect of oil and gas transactions, title issues within the framework of purchase and sale agreements. Our specific focus today is on how title matters impact transactions, how they're handled within a PSA, and the very real consequences they carry. Additionally, we'll discuss how title is verified during the due diligence period between signing and closing a transaction. You may ask yourself why this focus. Because title defects in oil and gas deals aren't just theoretical legal problems, they carry significant financial risks. They can directly impact the valuation of assets being bought or sold, jeopardize potential future revenue streams from production, and even create unexpected operational liabilities for the buyer down the road. Understanding how PSAs address these risks is paramount. So, when we talk about a title defect in the context of a PSA, we're not just talking about any cloud on title. We're talking about what this specific contract negotiated between the buyer and the seller defines as a defect. This definition is awfully heavily negotiated because it sets the boundaries for risk allocation related to title. It may reference a standard like defensible title or marketable title, but even that term is usually further refined or defined by the specific language of the PSA. You can think of the definition of title defect as the crucial gatekeeper. An issue identified during due diligence only gets through the gate to become an actionable defect if it meets the criteria laid out in this specific definition. Even if an issue falls outside of this specific definition or is listed as a permitted encumbrance, or falls below any sort of de minimis thresholds, which we'll get to those 2 points later, the buyer might have no recourse under the PSA's title defect provisions, even if it impacts the transaction's value. This is why understanding and negotiating this definition is critical. It directly controls when the seller has to act and when the buyer has remedies. The definition effectively creates the contractual standard for title quality for this deal, and it might explicitly disclaim stricter standards like marketable title, which is common in upstream oil and gas asset deals. So to continue on title defects, additionally, these title defects must not exceed the thresholds identified in the PSA. It's not enough for an issue to simply meet the technical definition of a defect. The PSA will sometimes include a monetary threshold, both per defect and in the aggregate. So an issue might technically be a defect according to the definition, but if its calculated value impact does not exceed the individual threshold, it doesn't trigger seller obligations. Likewise, even if individual defects pass the first hurdle, the total value of all asserted defects usually needs to pass an aggregate defect threshold before remedies apply. This prevents disputes over minor and material issues. However, I've seen instances where these minor defects have been asserted anyway, and the parties work together to cure them. So even if you have a title defect that doesn't arise to this, you can still assert it, and hopefully the seller is willing to work with you on that. However, they are under no contractual obligation to do so. So distinguishing title defects from permitted encumbrances. The title defect definition always works hand in hand with the definition of permitted encumbrances. Permitted encumbrances are specific types of burdens or title issues, like listed easements, existing agreements, or certain royalties that the buyer explicitly agrees to accept. Anything listed as a permitted encumbrance cannot be asserted as a title defect. Reviewing and negotiating the permitted encumbrances list is just as important as negotiating the defect definition. Clarity is paramount. Ambiguity here is the enemy. Without objective criteria or unclear standards, there are invitations for disagreement later about whether a specific factual situation meets the definition of a title defect. Well-drafted definitions are comprehensive but precise, using objective measures where possible. For example, a simple way to define title defects is if the actual net royalty interest or working interest is less than what is reflected on the attached exhibits. Common elements included. While the specific definition controls, you'll typically see the definition drafted to capture common issues such as outstanding mortgages, liens, or judgments, or significant discrepancies between the stated and actual net revenue interest or working interest. So again, whether any specific instance of any of these qualifies depends entirely on fitting the negotiated definition and exceeding the thresholds. So moving on to something that we've touched on already. We've defined what constitutes a title defect, but that calculated number doesn't automatically translate into a dollar-for-dollar price reduction. The PSA uses thresholds and caps to set financial boundaries. These mechanisms filter for materiality, ensuring parties focus on significant issues, and they limit the seller's financial exposure, providing greater certainty for both sides as they approach closing. So let's talk about individual defect thresholds. This is the first filter when it comes to these thresholds and caps. Each defect is looked at individually. For example, if the PSA sets this threshold at, say, $10,000, a defect calculated to be worth $9,000 is simply ignored for remedy purpose, even if it fits a technical defect definition of a defect. Only defects valued at or above this amount proceed to the next step. So the next step here would be the aggregate defect threshold. And this can be structured as a deductible or a basket. This is the second filter. You sum up the values of only those defects that individually exceed the per defect threshold, the first filter, and the total sum is then compared to the aggregate defect threshold. This aggregate amount can either be structured as a deductible or, less common, a tipping basket. The difference between those is a deductible works how you expect any sort of health deductible. You are responsible up to a certain point, and then once it exceeds that point, the other party is responsible. However, a tipping basket, once you reach that certain point, the other party would be responsible for everything from $1. This is also similar to how indemnities can be structured. So moving to caps. A financial consequence attributed to a defect affecting a specific well or lease cannot be greater than the value assigned to that specific well or lease in the PSA's allocated value schedule. It's a fundamental limitation that is very common so that the seller does not end up paying more in defects than the asset itself is worth. So calculating title defects. In each PSA, it will define how to calculate a title defect. So once an issue is confirmed as a title defect and it exceeds our thresholds that we just discussed, the next critical step is calculating its financial impact. Crucially, you don't just guess. The purchase and sale agreement itself dictates the methodology for calculating its value. You want to always refer back to the specific language in your agreement because there are different variations of how defects are calculated. However, typically, the defects amount is tied to the allocated value. Most PSA calculations are anchored to the allocated value. This value assigned to each specific asset, like a well or a lease, is an exhibit to the PSA representing its contribution to the total purchase price. Using the allocated value provides a pre-agreed baseline of avoiding disputes about the intrinsic value of any asset during the defect process. So, common calculation approaches. Proportional reduction. This is a very common way of calculating these defects. If Exhibit A says the net revenue interest for a lease is 75%, but due diligence shows it's only 70%, the defect represents a 5% reduction or a 6.67% relative reduction. And so you would apply that percentage reduction to the allocated value of that asset, and that's how you would calculate your title defect. Some PSAs include a specific example of how this practically functions. For defects like outstanding mortgages, mechanics liens, or judgment liens, the defect value is typically the actual amount of money required to pay off that lien and obtain a release. Some PSAs use a broader standard, defining the defect value as the actual decrease in the fair market value of the asset caused by the defect. While flexible, this method can be more subjective and more prone to disputes. It might require agreement between the parties or even necessitate appraisals or expert opinions if they can't agree on the value reduction. Title defect notice. So we've gone through how we calculate title defects and what a title defect is. Now that you have all of that information, it's time to assert a title defect notice under the PSA. This is buyer's official contractually required communication to the seller outlining the alleged title problems. The defect notice is usually submitted by email and must be submitted by 5 p.m. However, while this is the standard practice, this is all PSA dependent, so it's very important to be aware of these deadlines and prepare as they approach. So this defect notice is one of the most important procedural aspects, and the PSA will usually set a non-negotiable deadline. There's generally no grace period. Missing a deadline by even hours usually means that the buyer is deemed to have waived the right to assert any defects not included in such a timely notice. The assets are then typically considered accepted as is with respect to those unasserted title issues. So you'll want to pay close attention to the specific date, time, including the time zone, and the method of delivery permitted or required by the PSA's notice provisions. Now in this slide, I have dropped in a basic definition of a title defect notice, and I'll go ahead and read that. So such written notice shall describe the title defect in reasonable detail, including the legal basis therefor, identify the specific assets affected, state buyer's good faith estimate of the title defect value, and include copies of any supporting documentation reasonably necessary for seller to verify the existence of the title defect. Once again, if the title defect notice does not include everything that is specified in the PSA, it may not be a valid title defect notice, and such buyer would be accepting the assets as is. So the cure period. You've asserted a valid title defect notice, and now the seller is on the clock to cure. This is the time frame laid out in the PSA. It's often 30, 60, or 90 days, and it gives the seller a chance to fix the problems that buyers identified. The seller's obligation during this period is also defined, usually something like commercially reasonable efforts or diligent efforts to attempt to cure defects that they don't dispute. They aren't necessarily obligated to spend unlimited money, but they generally have to try in good faith. This, of course, is negotiated, and in some instances, there may be no obligation for seller to attempt to cure. So there's a few ways to cure these title defects. Scenario 1, successful cure before closing. In the best case scenario, the seller resolves the defect during the cure period. They might get a lien released, record a curative deed, obtain a necessary stipulation, and then they would provide evidence of that to the buyer. The buyer agrees that this is effective, the defect is removed from the list, the asset's transferred at closing at its full original allocated value. No harm, no foul. So a defect uncured by closing. Usually in this case, the buyer has some different choices that it can make. So what if the cure period ends or you reach the closing date and certain defects remain uncured? The PSA typically gives the buyer choices for each remaining uncured defect. Option A, waive the defect, accept the asset as is with the known defect with no price change for that defect. Option B, price adjustment. Buyer accepts the asset, but purchase price is reduced by the agreed title defect amount. Option C, exclude the asset. If the PSA allows, buyer may exclude the severely impaired asset entirely. In this case, the purchase price would be reduced by the excluded asset's full allocated value so that the buyer isn't paying for something that it's not getting. Another outcome, a post-closing cure. Parties generally prefer title issues to resolve before money changes hands. However, a known defect may require a lengthy process, such as litigation or a suit to quiet title. In these limited cases, the parties might specifically agree in the PSA to close the deal despite the defect, with the seller contractually obligated to complete the cure after closing. In this case, the purchase price relating to the asset is held back by buyer or an escrow until satisfactory cure is completed and a second closing occurs. Finally, the last option during the cure period is to terminate the PSA. This is the most drastic outcome, walking away from the entire deal. So a clause like this is usually triggered only by significant aggregate value of uncured defects. With termination threshold, buyer, or sometimes seller, it could be either party, gains the right to terminate the entire deal only if the total value of all remaining uncured title defects exceeds a high negotiated threshold. I'd say the normal range for this is between 10 and 20% of the original purchase price. In some cases, you may not have a specific threshold, where buyer gains the right to terminate the entire deal if any defects are discovered. And this is obviously very buyer friendly, so you'll want to watch out for something like this, depending on which side of the deal that you're on. So title benefits, the other side of the coin. A title benefit arises when seller can demonstrate that the actual title condition of an asset is economically superior to what is represented in the PSA exhibits used to determine the allocated value. The classic example is proving that seller owns a higher net revenue interest in a well or lease than the stated net revenue interest listed in the exhibits. So the process of this is similar to buyer's process for defects. The seller cannot simply claim a benefit informally. The PSA requires the seller to deliver a formal written title benefit notice to the buyer and must typically be delivered by the same title claim date deadline that applies to defect notices. However, the PSA will control whether buyer has to notify seller of any title benefits that they discovered during the buyer's diligence. So it's important for seller to understand what they're selling before they enter into an agreement. So to avoid minor adjustments, title benefits are often subject to thresholds, just as we discussed with title defects. There's often an individual threshold, and there's often an aggregate threshold. If a title benefit is properly asserted, documented, and exceeds the thresholds, and is ultimately agreed upon by the parties or determined through the dispute resolution process, the standard remedy is an upward adjustment to the purchase price paid by the buyer to the seller at closing. But depending on the PSA, title benefits may only be applicable to offset any title defects, meaning that the title benefits cannot increase the purchase price. So once again, it's important for seller to understand what they're selling before they enter into any agreement. Title benefits are a negotiated clause. It's a very heavily negotiated provision, and it's not present in every PSA. Buyers may resist their inclusion, but of course, sellers argue for their inclusion on the basis of fairness and symmetry with title defects. The existence of the clause and its details, such as the applicable thresholds and scope, depend entirely on the outcome of negotiations between buyer and seller. So another critical area informed by due diligence is the seller's representations and warranties regarding title. Representations are a statement of facts about the title as of a certain date, while warranties are promises or guarantees about the state of title, often providing recourse if they prove untrue. The strength and scope of the reps and warranties are heavily negotiated, often directly influenced by what the buyer finds or doesn't find during due diligence. A major point of contention is often their survival post-closing. Does the seller's liability for breaches of these title reps and warranties end the moment the deal closes, or does it continue for a specified period thereafter, perhaps a year, or will it extend through the relevant statute of limitations? Buyers obviously push for strong title warranties that survive closing, which provides them protection against issues that might not have been apparent during diligence or that surfaces later. Sellers naturally prefer to limit their post-closing liability and push for shorter or no survival periods. So with that, I'm going to pass this back to Shaun, and he is going to talk about the role of title opinions and impact on PSA negotiations.
Thank you, Braedon. Appreciate it. So now we've discussed a number of different issues related to title work and diligence in the PSA process. So now we're going to talk about what particular things in title opinions are relevant and what can we do to cure these title defects that we have identified. So title opinions serve as cornerstones of the buyer's due diligence in many oil and gas transactions. Prepared by examining attorneys, they offer an expert legal assessment of the seller's ownership based primarily on reviewing the relevant public property records, which may be found in the county or state records, or may be held in the Bureau of Land Management or the Bureau of Indian Affairs, depending upon where the asset or assets are located. As utilized in a real property transaction, the title opinion is critical in identifying potential title defects. These include breaks in the chain of title, outstanding liens, conflicting prior conveyances, issues with lease validity, and potential royalty burdens. This helps the buyer understand the specific title risks associated with the assets. However, it is crucial to recognize the inherent limitations of title opinions. They are typically based only on the public records, as we've discussed. Unrecorded agreements or interests generally won't be reflected. They also rely on certain assumptions, such as the validity of prior documents or the accuracy of airship information, and their scope might be limited to certain lands, depths, or formations. It's imperative for the parties to understand the explicit limitations set forth in any title opinion upon which they are relying. Remember, these are expert analyses of the records, not guarantees of perfect title. Because of both the risks and limitations identified therein, title opinions significantly impact PSA negotiations. Buyers frequently use the issues raised in title opinions, the requirements or comments section specifically, as a basis for negotiating specific provisions in the PSA. This could mean demanding targeted representations or warranties from the seller about a particular issue, seeking specific indemnities for identified risks, or using the opinion to refine the definitions of title defects or permitted encumbrances in the agreement. So the purchase and sale agreement itself outlines the buyer's rights and seller's obligations related to the title due diligence process. These provisions essentially set the ground rules for the buyer's investigation. Key elements include the scope of the review, what information and records is the buyer entitled to examine. This covers not only public records, but potentially the seller's internal files, systems, and data related to the assets. The PSA also typically addresses the seller's obligation to facilitate this access. Negotiating both the scope of diligence and the rights of access is vital for the buyer. A buyer needs sufficiently broad access to conduct a meaningful assessment of title risks. Common points of negotiation include access to the seller's internal land files, any existing title opinions the seller might have, division order records, production data that might impact lease maintenance, seller contracts and agreements, and sometimes the right to conduct physical site inspections. Sellers conversely may want to limit the scope to manage disruption and confidentiality. And in the event of site inspection, seller will want sufficient releases, indemnities, similar protections if the buyer or its representatives are physically present in the field. The PSA also establishes the time frame for this diligence, the due diligence period. This period is critical, as are the associated deadlines, particularly the deadline for delivering the title defect notices to the seller. Missing this deadline, as we've mentioned, typically results in the buyer waiving the right to object to any title defects not timely asserted. These negotiated timelines directly impact the overall transaction schedule, influencing how quickly the parties can move toward closing. So once the buyer has identified title defects, what actions can the parties take to cure these defects? One common tool used to cure title defects, particularly those arising from gaps in the chain of title due to inheritance, is the affidavit of heirship. Although the permissibility of affidavits of heirship vary from state to state, so it's important to understand the probate requirements in the state or states where the asset is located. In the case of an intestacy situation and without a formal probate, in many states the affidavit of heirship can be utilized, and we see it often in Texas, to ascertain the subsequent chain of title. An affidavit of heirship itself is just a sworn statement that typically identifies the deceased person, provides details about their family history, marriages, children, and other potential heirs, lists known assets and debts, and states that the facts are true based on the signer's personal knowledge. Critically, these affidavits are usually signed by one or more disinterested third parties. The requirements of that vary as well from state to state. These disinterested third parties typically are people who know the deceased and their family well, but do not stand to inherit from the estate themselves. This adds credibility to the instrument. In the oil and gas world, where mineral interests can be severed and passed down through generations, unprobated estates are common sources of title gaps. Affidavits of heirship typically provide a practical mechanism to bridge these gaps and identify the likely current owners for leasing or transactional purposes. Within the PSA context, if a title defect is identified due to a lack of probate, the agreement might explicitly allow or require the seller to cure it by obtaining acceptable affidavits of heirship. The PSA may even specify requirements regarding the form, the content, or numbers of affidavits needed to be considered a sufficient cure. The seller is then responsible for procuring these affidavits and providing them to buyer for review during the cure period. It's important to note that there is jurisdictional variation as to when an affidavit of heirship is sufficient or permissible, but the parties to the transaction are free to contract as between themselves for risk mitigation. If a particular jurisdiction requires a formal probate proceeding, then the affidavit of heirship can be seen as a mechanism to decrease risk for the purpose of the transaction. Any such formal proceeding that may be necessary can be done post-close. Another frequently used curative tool is the quitclaim deed. Its primary purpose is to clear up potential ambiguities or clouds on title by having someone who might theoretically have a claim to the property formally relinquish any interest that they may possess. In a quitclaim deed, the grantor transfers whatever right, title, or interest they happen to hold in the property, if any, to the grantee. Importantly, a quitclaim deed comes without any warranty of title. The grantor isn't promising they own anything. They are simply giving up any claim they may have. This limitation is key. If the grantor actually owns nothing, the quitclaim deed conveys nothing. It doesn't create title where none exists, but it can effectively remove a potential claimant from the picture. In oil and gas transactions, quitclaims are often used to address issues like potential stray interests held by remote heirs, clearing old leases that may have expired but were never fully released of record, or resolving ambiguities where a party might have a questionable claim arising from poorly drafted prior documents. From a PSA perspective, if due diligence identifies a specific party who might hold such a potential conflicting interest, the agreement might require the seller, as part of its curative obligation, to obtain a quitclaim deed from that specific individual or entity. This helps clean up the record title being delivered to the buyer. Sometimes title defects are too complex or contested to be resolved through affidavits or quitclaims. In these situations, a more formal legal remedy, a suit to quiet title, may be necessary. This is a contestable lawsuit filed in court. The parties seeking to clear title, often the seller in a PSA context, sues any and all individual or potential adverse claimants, asking the court to definitively determine ownership and issue a binding judgment that resolves the title issues. Quiet title actions are rare and typically reserved for more serious title problems, such as competing chains of title stemming from historical errors or disputes over boundaries or interpretations of old deeds. Even situations where potential claimants are unwilling to sign quitclaim deeds. It is used when less formal methods are inadequate or unattainable. Compared to other curative measures, quiet title suits are significantly more formal, take much longer, sometimes months, even years, and are considerably more expensive due to legal fees and court costs. Given these characteristics, the PSA needs careful consideration if a major defect might require such action. The agreement should address how the costs of the suit will be allocated, almost always falling on the seller. Critically, the lengthy timeline means a quiet title suit often cannot be completed before the scheduled closing date. This may require the parties to agree to extend the closing or potentially close with the defect uncured, but subject to a post-closing obligation on the seller to complete the suit, likely secured by a significant escrow or holdback of funds. A very common and essential curative action involves obtaining releases for monetary liens and encumbrances against the property. These include mortgages the seller may have taken out against the assets, judgment liens resulting from lawsuits, unpaid tax liens, or mechanics and material maintenance liens filed by unpaid oil field contractors. The process involves the seller, or often the closing agent on the seller's behalf, paying off the underlying debt owed to the lien holder in full. Upon receipt of payment, the lien holder executes a formal document known as a release of lien, or similar name like release of mortgage, satisfaction of judgment as applicable. A critical step is that this executed release document must then be properly recorded in the official public property records for the county where the property is located. Recording provides public notice that the lien is no longer attached to the property, effectively clearing it from the record title. In oil and gas transactions, ensuring these releases are obtained is vital, as buyers require title free of such financial encumbrances. These liens could otherwise jeopardize the buyer's ownership and ability to finance or develop the assets. Virtually every PSA requires the seller to remove all non-permitted monetary liens at or before the closing. The seller is obligated to provide the buyer with evidence, usually in the form of the recorded release documents, confirming that this has been done. So as we've discussed, title opinions are primarily based on the instruments found in the public records. However, instruments not filed in the public records can still affect the rights and interests owned and duties and obligations borne by the seller. Typically, these unrecorded instruments are referenced in an instrument which is itself filed of record. So an assignment may be made subject to the terms or provisions of an unrecorded letter agreement, or a joint operating agreement, or a participation agreement, or a joint exploration and development agreement, or anything like similar to those agreements. The title opinion should identify any unrecorded instruments the examiner found reference to in the course of their examination of the records. The buyer should request the seller provide such instruments or obtain them from a third party if they are not in the seller's possession. As a general rule, a buyer is on notice of the contents of an unrecorded instrument when a recorded instrument refers to or is made subject to the unrecorded instrument itself. This varies somewhat by state, but most states follow this line of thinking. Therefore, it's imperative for the buyer, as part of the diligence process, to identify any of these unrecorded but referenced instruments. The terms found in the unrecorded agreement attach to the assets and will follow the transaction. As a buyer, you want to know what obligations, restrictions, or otherwise you may be taking on. These agreements can impact both the valuation of the assets as well as the ability of the parties to close timely and efficiently. So a number of the different instruments we'll discuss now. So letter agreements may contain back-ends, reversions, or conversions, which upon some triggering event may decrease the seller's interest in an asset. The buyer will need to incorporate this information into a valuation model and determine if it rises to the level of a title defect as such as defined in the PSA. Rights of first refusal, preferential rights to purchase, consents to assign, typically set forth a time period for the third party holding such right to exercise that right or provide such consent. If the time period elapses, then such right terminates as far as it affects the subject transaction. From the parties' perspectives, these rights can delay or even kill the deal. From a seller's perspective, it's helpful to know the timelines required under any of these provisions and have the necessary requests ready to send to the third party when the commercial terms have been reached. From a buyer's perspective, you want these resolved quickly, not just to close on schedule, but you don't want to continue diligence efforts only to find out a third party has exercised their pref right. The theoretical risks identified during diligence get translated into contractual rights and obligations during the process of negotiating the terms of the PSA. The primary goal here is twofold: fairly allocate the identified title risks between the buyer and seller, while also ensuring the transaction can proceed efficiently towards closing. Before diving into specifics, understand your negotiating leverage. Is it a seller's market where buyers have less room to push, or a buyer's market? How unique or desirable are these assets? Your overall negotiating power will influence how successful you are on shaping specific title points in your favor. There's always a balance to strike. The buyer understandably wants maximum protection against title risks. This means pushing for low defects thresholds, broad representations and warranties that survive closing, and strong cure obligations. The seller, conversely, wants certainty, finality at closing, and speed, leading them to advocate for higher thresholds, limited reps that expire at closing, and less burdensome cure obligations. Finding a commercially reasonable middle ground that reflects the deal's economics and the party's desired timeline is key. Don't let disproportionate focus on minor title issues kill an otherwise beneficial transaction. Crucially, tailor the PSA language to the specific risks you've identified. Don't just rely on standard template language. If your initial diligence uncovered specific concerns, maybe complex airship issues in a particular county, documented access problems, or questions about the validity of key issues, address those directly. This might involve drafting very specific representations or warranties, seeking targeted indemnities, or refining the definition of a title defect or the list of permitted encumbrances to reflect these known issues. During negotiations, keep focused on the key commercial terms that truly drive the risk allocation, the dollar figures for the individual and aggregate defect thresholds, and confirming if the aggregate threshold functions as a deductible, the length of any survival period for title warranties, the precise standard defining the seller's efforts required to cure defects, and any cost caps, and that critical percentage or dollar amount for the aggregate defect value that triggers a party's right to terminate the entire deal. As we wrap up, let's reinforce the most critical takeaways from our discussion on navigating title issues in oil and gas PSAs. First, remember that title provisions aren't just boilerplate. They are fundamental risk allocation mechanisms. How they are drafted and negotiated directly determines who bears the financial burden if title problems arise. Second, precision in language is paramount. Pay meticulous attention to the definitions within the PSA, especially title defect, permitted encumbrances, allocated value, and the various financial thresholds. Clearly defined terms prevent misunderstandings and costly post-closing disputes. Third, due diligence and the PSA are intrinsically linked. The findings from your title review, the issues uncovered in title opinions or record examination, must directly inform how you negotiate the PSA's title provisions, including specific representations, warranties, and potentially tailored indemnities. Fourth, understand the procedural mechanisms. Know the critical deadlines for the defect notice, how the cure period operates, and the potential outcomes. Primarily purchase price adjustments, which are often subject to deductibles, or in a significant case, the right to terminate if a high negotiated aggregate defect threshold is exceeded. Fifth, familiarize yourself with common title problems and their solutions, recognizing typical issues like outstanding liens, airship gaps, lease ambiguities, identifying and reviewing unrecorded instruments, and knowing the standard curative tools like obtaining releases, affidavits of airship, or quitclaim deeds allows for more efficient problem solving. And then finally, successful transactions require balance. Effective negotiation involves finding a reasonable middle ground that protects the buyer from unacceptable title risks while providing the seller with appropriate certainty and facilitating an efficient closing process. Understanding these concepts allows both parties to approach title matters strategically. By keeping these key points in mind, parties can more effectively manage title risks and increase the likelihood of a successful closing in their oil and gas transactions. We appreciate everybody attending our webinar. You can scan to subscribe our newsletter, the QR code that is on your screen. And we look forward to the next in our series, and hopefully you guys will attend that as well. Appreciate it. Thank you.